All right, everybody. We are back with another ruling in the NASCAR antitrust case. It's Wednesday, September 3rd, and the judge, less than an hour ago, has denied the team's preliminary injunction request. This was the latest preliminary injunction request by the teams. So we're going to unpack this a little bit here and talk about what it means for the broader scope of the case. And I will give you my take on why the teams lost this request. So, what were the teams asking for? So, first of all, last week, less than a week ago, last Thursday, the teams were very concerned that NASCAR was going to sell their charters out from underneath them before the trial was able to take place and gets resolved. It's supposed to start December 1st. Obviously, there's not a lot of time left this season. There's only 9 more races. And the judge is very aware that, the teams at this point are not likely to miss any races. In fact, he cites that NASCAR changed the rule in July to say, well, if there's going to be more than 40 cars, we have the right to limit the amount of cars that are in the race. They did that so that it would guarantee that 2311 and Front Row wouldn't miss any races. And NASCAR, of course, wasn't doing this out of the goodness of their heart. It was a smart legal move on their part to show that, hey, the teams are going to claim that they're going to be irreparably harmed here and they need an injunction. But guess what? They don't, because they're not going to miss any races. Obviously, the teams as well are saying, hey, we could lose our drivers. Tyler Reddick filed a notice with us saying that we're in breach of his contract. And, oh my gosh, what's going to happen? He could leave. And the judge is looking at this saying, you haven't really proved that because there's only 9 races left at this point, and he hasn't left, at least this year. So I'm not really worried about that for the remainder of this season. So what he's looking at is the judge back up for a second. He says, listen, if I'm going to give you a preliminary injunction, so I'm going to step in here and grant you these rights. It's an extraordinary standard to meet. And the judge is citing a case that you may be familiar with. It is this very case, the 2311 racing case, that went to the appeals court. The appeals court overturned the first preliminary injunction earlier this year that this judge granted. And one of the things that the appeals court said in it is that it has to meet 4 things. But one of those is that it clearly has to mean that the teams are going to succeed on the merits of their case. So they want the judge to forecast that they're going to win in December if he's going to give them this injunction, along with irreparable harm. So harm that is going to happen to them if they don't get this, that can't be undone. The public interest, balance of equities, whatever. Anyway, but those are the 2 most important things that he's considering here, right? And so the judge said in his case on the other day, he's like, please don't make me do this. I really don't want to rule on this case before the trial. He's worried that it's going to poison the jury pool, because if the judge comes out today and he says, hey, listen, yeah, you know what? I'm going to give them this preliminary injunction or not, because they're not going to succeed on this case, or they will. He says he's, quote, worried about it's going to thereby potentially bias the jury pool. And he doesn't want to do that, quote, unless it is necessary to do so, which he says it is not here. He said it's best not to forecast that. So he really did not want to do that. And so he found a way in considering this case to not do that. And the way he got around it is he focused squarely on the irreparable harm part of this case. So the irreparable harm, again, the teams are saying, hey, the NASCAR is going to sell the charters out from under us. And so even if we win this case, we're not going to be able to get them back. We won't be able to run as charter teams because there won't be any available. So NASCAR in addition to the rule I talked about earlier, right? They changed the rule that says, don't worry, you're not going to miss any races. The teams couldn't prove that they weren't going to lose their drivers. And then NASCAR on Friday, after the preliminary injunction, they filed this notice. And they basically told the court, hey, listen, all right, we know that you're worried that we're going to sell a bunch of charters here, or hand out new charters to new teams, new people that want to be in it. Don't worry, because we're going to leave at least 6 spots open. And so if we lose, for whatever reason, if we lose, there'll still be 6 charters available that these teams could get back, 3 each for 2311 in front row. So if we hand out any new charters, it's not going to be more than 4. So don't worry about it. And we're not going to distribute the disputed Stewart-Haas Racing charters. We're not going to do that. So this was very key information for the judge, because in his mind, those 2, he called them critical changes, and it proved to him that they would not be irreparably harmed. So in that sense, he's saying that he's not, he's not weighing in here on whether they're going to win at the trial or not. This has really nothing to do with the overall case. This is just whether the teams, and by the way, the teams answered yesterday, Tuesday. They answered NASCAR's notice from Friday, and they did not agree. For what it's worth, they did not agree, and they said, "Okay, well, NASCAR's offering this, but we asked for this, and this. They asked for more, and NASCAR said, no, we don't agree with that. But what NASCAR said was enough. Again, so and the judge says that he feels like even without granting this preliminary injunction, he says, quote, there will be sufficient equitable remedies and tools available if the plaintiffs prevail at the trial. Now, he warns again, though. He again says, you may not like this. You may not like what I decide when it comes to this trial, which is, again, a warning that he gave from the bench on Thursday. He says in this ruling, quote, the uncertainty about what the 2026 season will look like unfortunately exists, not just for the parties, so not just for NASCAR and the teams, but for the other teams, drivers, crews, sponsors, broadcasters, and most regrettably, the fans. So he again is saying that I have a lot of power here to change the entire sport, to change NASCAR as we know it, if you're going to go through with this trial. So again, sort of urging them to settle in one way, but also in another way, also saying, by the way, you're asking me to rule on something here about a sport for next year and all this stuff that may not even, it may not even take place. Like this thing may look totally different, right? A couple other things. One thing, I'm fairly new to the whole court thing. I'm no Bob Pockrass here, so I haven't been studying this for years and years. But one thing I really enjoyed is seeing the notes that the judge puts, the little footnotes, and one of those is here I'm going to read a couple. So one of them is he talks about the teams are saying, hey, NASCAR won't even acknowledge that we bought the Stewart-Haas charters, and NASCAR won't even acknowledge them. Please make them acknowledge that we own these charters so they can't get rid of them. He says that while he acknowledges that the court does not need to resolve that ownership claim in this order, in the preliminary injunction order. He says that will all be determined after trial. He also says, quote, and I'm just going to read this directly because this has been a big thing that NASCAR says. He says, NASCAR repeatedly states that the charters were issued for free. And just to back up for a minute, this is not his quote, but Chris Yates, the NASCAR attorney, he focuses a lot on this in his courtroom arguments. He says, NASCAR's view is, look, can you believe these teams? We gave them these charters for free. We've created tens of millions of dollars in value for each car, and they didn't have to pay for these. We gave them these charters, and now they're worth over $40 million each. So can you believe that, right? So the judge kind of takes exception with that here. He doesn't love this argument. He says, NASCAR repeatedly states that the charters were issued for free, but this is, at a minimum, misleading. While the charter agreements do not require any direct monetary payments from the teams to NASCAR, the agreements reflect the parties' mutual bargain on a bundle of rights and obligations, including the team's numerous commitments to, quote, operating obligations and sponsor exclusivity, and allowing the use of their intellectual property that impose both significant costs on the teams as well as provide substantial benefits to NASCAR. So what he's saying is, yeah, you might have given them for free, but you get something out of them as well, NASCAR. So he didn't love that NASCAR makes this argument here. So the bottom line is, if you're just joining in to do like a TLDR here of this preliminary injunction, is he focused on whether the teams would be irreparably harmed, some harm that they can never come back from, like they're going to lose their drivers, they're going to miss a race, and it's going to cause them to lose sponsors. Or in this case, what was really focused on was NASCAR selling the charters before the trial so that they could never get them back. And by the way, the judge agrees with NASCAR that the teams they don't own the charters. He says they didn't sign them, and they chose to bring a lawsuit and said they don't belong to the teams. He says these are not the charters that they could, quote, get back in a way, but he could award them in the as part of the relief. Now the teams have asked for triple damages and all that stuff, but anyway, so even though Tyler Reddick, has filed a breach of contract notice with 2311 saying, hey, you didn't fulfill your obligation to put me in a chartered car. The judge seems, he doesn't really believe, and he doesn't think the teams have provided proof that Tyler Reddick could actually leave and go to a different team at this point in the season. And so he says there's really no need, and there's really no justification for me to issue you this preliminary injunction order. And so, that's where it stands. But again, I don't really think this actually indicates anything in terms of the overall case. And in fact, the team's lawyer, Jeffrey Kessler, seems to agree. So here's the statement that he put out. And of course, there's always some spin in what the attorneys put out, but this is what he put out after the ruling. And this is the team's attorney. We are grateful that Judge Bell has made clear that the status quo is being maintained, protecting my clients' rights to regain their charters if they prevail at trial, and ensuring their ability to continue racing through the 2025 season based on NASCAR's commitments. Equally important, Judge Bell reaffirmed his broad power to order meaningful changes in NASCAR should we succeed, so that teams, drivers, sponsors, and fans can benefit from a sport positioned for long-term growth and restored competition. We are ready to present our case at trial in December. So again, this seems to be, listen, hey, we're going toward trial, folks. Neither side seems to be able to come to, they couldn't even agree on this. Like NASCAR filed their notice on Friday saying, all right, fine. We're not going to, we'll appease a big part of this preliminary injunction hearing. Right. And so don't worry about it. We're not going to sell more than 4 charters. We'll keep enough charters for you, for everybody. And the teams still didn't disagree. They talked over the weekend, or still didn't agree. They talked over the weekend, and they couldn't come to a resolution. And so it just doesn't seem like at this point there's going to be any settlement, even though the judge keeps urging them and keeps warning everybody, sport could change forever. So that's pretty much it. That's pretty much what I took from this. And we will just, I don't know that we're going to see at this point another big sort of moment before the actual trial, unless it's the settlement, obviously, right? Because now, while I think that, you'll see there's going to be some back and forth on the discovery stuff and what's admissible and, all that kind of thing. But in terms of like the big things, at this point, they're going to finish out the season. It's close enough to the end of the season that the teams are going to be okay, right? Like they're going to finish out this year. They're going to run as open for the rest of the year. And the other teams, NASCAR has told the other teams that they're going to get the money. I think it's $1.5 million per car. They're going to get that because they don't have to pay the 6 cars now. So that's going to be reallocated the money to the other teams. The other teams will be happy. By the way, it doesn't seem like 2311 and Front Row intend to pay the money back that they already got as running as under the chartered status from the preliminary injunction that they got granted that got overturned. So NASCAR still wants that money back, but that's going to all be resolved at trial as well, right? Because again, the teams are asking for triple the damages that NASCAR would owe, whatever the judge would find. But the judge said, listen, I can make you sell the tracks, NASCAR. I can do all sorts of things. So, yeah, it's going to be really wild if this goes to trial. And, Jackson Watkins here in the comments, I just see a comment popped up. He says, do you think an IndyCar style split is a possibility? I didn't think we'd get close, but the uncertainty is concerning. I think that's on the table, right? I mean, that's on the table because this is what the judge basically said, that this is possible. He could, if he finds that NASCAR is a monopoly, he could break up NASCAR in a sense. Now, I don't know that that's what the teams are going for, but the teams are certainly, I think, would want to use sort of that threat to make NASCAR, settle and give them what they're looking for. But they're talking about they want structural, meaningful change at this point. So anyway, that's pretty much it. I don't know. I don't really know if we won't have an oh, wait, it's not it. Because there's a NASCAR statement that has just come in via text just this minute. So I'm going to read you this live. I haven't even read this first. Okay? Reading this live right here. Now, this is a statement from NASCAR. We welcome the court's decision, which brings much needed clarity to the remainder of the 2025 NASCAR season. For nearly 80 years, NASCAR and the France family have championed a bold vision by taking many personal and financial risks to build a sport that fuels livelihoods, inspires generations, and delivers world-class competition. That commitment remains unwavering, and we will continue to defend the integrity of NASCAR and preserve the values that have guided its growth. And there's a message to the fans here as well from NASCAR. To the fans, we won't let this lawsuit distract from what matters most, delivering the unforgettable moments you've come to expect from our great sport and crowning the next NASCAR Cup Series champion on November 2nd. So, in a way, it sounds like everybody for now is just steamrolling toward the trial, December 1st. Get your popcorn ready if that happens, because the sport could change forever if this really goes to trial. If they do settle, both sides are pretty dug in. If they do settle, it probably won't happen before, the last minute, right? I mean, we could be talking about the night before. It's going to be right after Thanksgiving weekend. So could this be sometime over Thanksgiving weekend? I don't know, but it's going to be a game of chicken going all the way to the end if they really want to go to trial. But both sides seem to be determined to go at this point. So we will see what happens. Anyway, hope that helped explain some things. Check out our coverage on The Athletic as well. Jordan Bianchi is writing up an article as we speak. So thanks for listening, everybody, and talk to you next time.